Now, if you're going to try to run my courtroom, then I need you to go to law school and get either elected or appointed to the bench. You're going to keep acting like I'm dumb, because I'm not. But if you go low, I'm going lower. I'm going to show you how deep I can dig down into the gravel.
You can feel it right from the moment he steps in. That's silent defiance. The body language says it all. Arms crossed, jaw tight, no respect for the process. And Judge Bryant, she's not the type to let that slide for even a second. The way she locks in, voice calm but sharp, you know she's about to send a message, not just to him, but to everyone watching. What makes this moment so intense is that she's not yelling or overreacting. She's controlling the entire room with pure authority. It's that quiet power, the kind that makes you sit up straight even if you're just watching through a screen. You can tell she's heard about his attitude and is ready to draw the line. There's no fake charm or yes, ma'am. That's going to get him out of this one. Every word she says feels like a warning wrapped in professionalism. Let's see how this unfolds, because when Judge Bryant decides she's had enough, things usually turn very real, very fast.
All right, go ahead and call the case number.
My trial was yesterday.
Sir, can you be quiet? I already told Ms. Stevenson to tell you that I wasn't going to do that with you. Now, if you're going to try to run my courtroom, then I need you to go to law school and get either elected or appointed to the bench. But if I'm going to run my courtroom, I am going to run my courtroom. And I know everything that's going on in my courtroom, and I don't need your assistance.
The defendant is charged with malicious destruction of property, less than $200.
And when was it on the court's docket for?
It was on the court's docket for June 27th for a jury trial.
Thank you. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Darrell Smith. Mr. Smith, sir, please unmute and just tell the judge your full name.
Darrell Donnell Smith. My paperwork had trial for the...
You're going to keep it up, and let me tell you what's going to happen. That $10,000 cash surety bond with the house arrest, I'm going to keep it in place. You're going to keep it up. You're going to keep it up. But let me help you with something, Mr. Smith. You're going to go low and I'm going to go lower. You're going to keep it up. You're going to keep acting like I'm dumb, because I'm not. Ms. Stevenson, how are we proceeding today?
Thank you, Your Honor. We, first of all, thank the court very much for allowing Mr. Smith to be a walk-in today. We thank the court for allowing him to appear without having to post the bond, which was ordered on June 27th. I am asking the court, first of all, to set aside the capias, which I believe the court did issue on June 27th for Mr. Smith's failure to appear, and I'm asking that the matter be rescheduled for final pretrial conference.
The court is going to set aside the capias and recall the warrant. I'm not going to set a final pretrial conference, but it is my understanding that despite the fact that I, on this record, gave the date for the jury trial, despite the fact that the jury trial for this case has been set, I don't know for how many months. I don't know how many months it's been set for. The clerk in his entry put the wrong date in the system. And so instead of paying attention to what I said on the record, because he had the stank attitude the last time he was in court, and he hurried up and clicked off, and he was probably turning his head like he's doing now, and he probably wasn't paying attention to nothing that the court said. And so that's how he wasn't able to hear the actual date of the jury trial. The date of the jury trial that everybody showed up for except Mr. Smith. The date that I showed up, the date that counsel showed up, the date that the prosecutor showed up, the date that all three of the witnesses showed up to, the date that all of the jurors showed up to. Everybody showed up on the date that had been set for months, except Mr. Smith, who indicated to you, according to you, that he looked in the court system, saw on the register of action that it was set for June 28th, which the court will admit was a mistake by Mr. Flanagan, who just had his own paternity leave, and I'm so excited for him. But Mr. Flanagan mistakenly put the date in as June 28th, which is why this court, who's been practicing law for 30 years, been on the bench for 16, know her job so well she could do it in her sleep. That's why I don't go by a register of action. That's why every time we come into this courtroom, I say that the register of action is not an official record. Why? Because the clerk can make a mistake. Because the clerk can type anything they want to type in that register of action. I don't type in the register of action. The clerk types in the register of action, and they could put any information they want to put in that register of action for a final pretrial conference. But Ms. Stevenson, I believe you have a motion.
Yes, Your Honor. The primary reason for my request for a final pretrial conference is the fact that Mr. Smith and I, Your Honor, unfortunately, are just not able to work together. I do believe, Your Honor, there has been a severe breakdown in the attorney-client relationship, Your Honor, which I would argue would interfere with my ability to zealously represent Mr. Smith the way that my oath requires me to, Your Honor. I don't. There's only maybe about 5 times in my career have I asked to be replaced. Because of the relationship that I'm having with my client. I have clients that are just, at each end of the spectrum with regard to being easy to work with. Some of them are really, really, really easy to work with. Some of them are very, very, very challenging to work with. But, I do the best that I can. Mr. Smith, despite what he's indicated this morning, I don't believe that he has confidence in my intellectual ability to represent him as an attorney, Your Honor. Mr. Smith, I'm almost 60 years old, and for the first time, somebody called me slow. That's what Mr. Smith said to me. Despite my efforts to try to get him into court, back in here today after the court's order, with regard to the capias, we just had a very difficult time, or maybe he didn't, but I had a really difficult time just trying to help him even yesterday. So for Mr. Smith, it is in his best legal interest, I would argue, that someone other than myself and my partners with misdemeanor and felony defenders be appointed to represent Mr. Smith. We do collaborate on our cases. I've had conversations with my partners and with our supervisor with regard to this case, Your Honor, and I'm asking that Mr. Smith be given a different lawyer, somebody who'll be able to work with him, Judge.
Mr. Smith, did you have something to say in response to Ms. Stevenson's request to be removed from your case? I can't hear you, Mr. Smith. You're not muted, but I can't hear you. You're not muted, but I don't know what happened with your device, but you're not muted. You're not muted, but we can't hear you. That's what I'm saying. Can't hear you. Still can't hear you. Did you disconnect the volume? Did you? Okay, so maybe you need to log off and log back in. There's something wrong with your audio. We can't hear you. We can't hear you. We can't hear you.
I'm trying now. How about now?
Yes, we can hear you. We can hear you.
Now, in regards to the email, it came at 11:53. When I checked the register of actions, the court date had set it for 6/28. I had an interview with Amazon and training to start, so I was actually happy to see the 28th in there. So, because it went along with that interview schedule. So the email on the 27th came real late, and it sent me into a panic, and I was like real nervous there, but I had to go back to the register of actions, and I had sent a text message to her, and like it was just that part.
Here's my question, Mr. Smith. Ms. Stevenson has requested to be removed from your case, and I'm asking you, do you have any response to her request to be removed from your case?
I'd rather she stay. I don't want this process to take any longer than it has. I'm having a real difficult time with this.
Okay, so you called her stupid, basically.
No, that email came at 11:53.
No. She said you called her slow.
I mean, if the email would have came at 9 o'clock in the morning, then I would have called her fast.
Exactly. This is textbook Judge Bryant. She doesn't need volume to dominate the room. Her tone does all the heavy lifting. What makes this moment so powerful is how she reads him without him saying a word. The crossed arms, the blank stare, the stiff posture. That's all it takes for her to remind everyone that attitude is evidence in her courtroom. And she's right too. Court isn't just about what you say. It's about how you carry yourself. The wrong energy can speak louder than any disrespectful word. Judge Bryant doesn't humiliate him. She educates him, which is even more impactful. It's that calm, surgical kind of authority. Not anger, not ego, just pure control. This is one of those moments where you realize why judges like her run such tight courtrooms. It's not about fear. It's about presence.
Really? That's how you want us to interpret that?
Please do.
Well, we don't. Because let me tell you what occurred yesterday. Yesterday on June 28th, I was informed that Mr. Smith had misunderstood and that he showed up for his trial date a day late. I said, okay. I don't know why he checked the register of action instead of calling the courtroom. When the register of action said something clearly different than what the judge said, seems to me like an individual would immediately call their lawyer or call the courtroom or call and say, hey, the judge said the 27th, but I'm looking in here and it say the 28th. And then before we could even address the issue yesterday, I was informed by security that Mr. Durrell Smith had been removed from the building because he was acting out in the hallway.
I have video.
I'm talking. I was informed that Mr. Smith was removed from the building because he was being unruly in the hallway. And then I informed Ms. Stevenson. Ms. Stevenson, your client has been removed from the building. So you're not going to be able to speak with your client because he has been removed from the building by security. And then Ms. Stevenson was texting me and stuff and begging me and stuff because she is a phenomenal lawyer. She was telling me, Judge, please, can Mr. Smith come in tomorrow? Can he come in tomorrow? And then I sent her a text back. And I don't know if she forwarded you my text, but she said something about, Judge, it was an honest mistake that he made. And I said, no, it wasn't. I said, it wasn't an honest mistake. I told him on more than one occasion, the date for this jury trial. That last final pretrial was just a last final pretrial confirming what we already knew, that the jury trial was going to be set for June 27th. But I remember when you logged off on that day of the last final pretrial, and I said, if he don't change his attitude, this is going to be a difficult jury trial. Because that was a short little routine hearing, yet your attitude sucked. I mean, you come on here as if I have accused you of maliciously destroying some property at the jail. You come on here like you just mad at the world, like you, and since we included in the world, you mad at us too. Your attitude, it just sucks. And I have, as long as I have been a from the very beginning of my career, I should say at some point early in my career, Ms. Stevenson, I believe this is only her second request to be removed from a case. Even when she has had clients that I've had to threaten to put in jail, that I've actually put in jail for their stank attitudes, and Ms. Stevenson has not given up the fight. And she's always amenable. to continuing on with a difficult client. That not only is the client difficult, but he's abusive in his manner in which he speaks, that you have used profanity in the way and manner that you speak. It's unacceptable. It's unacceptable. It is absolutely unacceptable. And since she wants to maintain her license, she apparently didn't curse back at you. But I might not have been that kind of lawyer. Because when you go low, and I love Michelle Obama, I respect her with the utmost respect. But if you go low, I'm going lower. I'm gonna show you how deep I can dig down into the gravel.
Exactly. That moment right there is peak Judge Bryant. She doesn't raise her voice. She doesn't lose her cool. She just dismantles his attitude piece by piece with pure authority. The way she checked him for disrespecting his lawyer wasn't just about protecting the attorney's pride. It was about protecting the integrity of the courtroom itself. When she told him, in so many words, "You don't get to insult the person trying to help you." That hit hard, because she's seen it 100 times. Defendants acting like public defenders are beneath them, forgetting they're the only line standing between them and a much worse outcome. And you can tell this wasn't her first rodeo. The tone in her voice wasn't angry. It was disappointed, like a teacher reminding you that your own arrogance is the problem. It's rare to see a judge defend a public defender that passionately, but it says everything about who Judge Bryant is. She values respect over theatrics, and she'll shut you down instantly if you don't get that.
So I want you to stop. I want you to stop with this behavior. You have been accused of something. You are innocent until proven guilty. And we are going to get counsel appointed to Mr. Smith. So I'm going to set a new date for a final pretrial conference. And then Ms. Ritter, I need for you to see if your witnesses are going to be available, because I am going to bump that was on June 21st that I confirmed that the trial was June 27th, just for this record. On June 21st, I confirmed that the trial was on June 27th. So the week before, I specifically said that the trial is on June 27th. Okay, I'm going to set the final pretrial conference for next Wednesday, July the 5th. So I need for Ms. Carter to assign counsel to Mr. Smith so that I can then hurry up and select another jury trial date for Mr. Smith. And that means I am going to bump a jury trial that's already scheduled. So we need to maybe see one of the ones that might, be a best choice to bump. So I'm going to bump a case.
Cool. Exactly. This hearing turned into unintentional comedy gold. You can literally feel Judge Bryant's patience evaporating by the second, but she's too seasoned to even interrupt. She just sits there with that calm, piercing stare like, "Go ahead, dig that hole a little deeper." It's the kind of silence that hurts more than yelling. That "I expected better from you" silence. And this guy, he's so busy trying to sound profound that he doesn't realize he's basically building the prosecution's argument for them in real time. The funniest part is how serious he thinks he sounds. You know that tone people use when they believe they're dropping wisdom, but everyone else in the room is just trying not to laugh. That's this moment in a nutshell. By the end, it's not even a legal exchange. It's performance art in denial. School. Final version, refined for voiceover/script use. Court doesn't always explode with drama. Sometimes it's just slow motion humiliation under fluorescent lights. This wasn't some wild meltdown. Well, maybe a quiet one. A slow unraveling in real time. And Judge Bryant? She handled it like a pro. Didn't yell, didn't lose control. Just calmly dismantled every ounce of nonsense he tried to bring in. Some people walk into court thinking they're smarter than the system, and then reality shows up in a robe. Makes you wonder, how many defendants would save themselves if they just sat down and listened for once? Anyway, let me know what you thought about this one down below. I post clips like this every day, so don't forget to hit that like button, subscribe, and I'll see you in the next